So, good evening, everybody. I call to order the Select Board meeting of Tuesday, October 9th, 2025. I'll try that again. Are you able to hear me now? Thank you so much. So, I call to order the Select Board meeting of Thursday, October 9th, 2025. The time is 7:05. There's a quorum of the board present. We have Mr. Gito, Vice Chair Ms. Roberts. On my right, we have Mr. Carrera and Mr. McCrisky. For all those who are able, would you mind rising and joining me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. We have two items on the agenda this evening. I appreciate that. I'll get pretty close to this thing. Thank you so much. I'll get real intimate with this microphone so we can make sure that everyone's able to hear. So we have two items on the agenda this evening. The first is a discussion regarding the SMAC lawsuit against the town of Stoughton. And I just asked Mr. Winter to provide an update to the board and to the public on that. And the second is a public hearing regarding the contract dispute between the town of Stoughton and Stoughton Media Access Corporation. So we're just going to turn the microphone over to Town Council, Mr. Attorney Winter, if you don't mind providing an update of current status on the lawsuit for the public and for the board.
Certainly, Mr. Chairman. And let me just offer a little bit of a preface. I mean, normally we would give these updates in an executive session, but I asked that this be done in open session just to give the board and the public a brief update on sort of what's transpired in the last 24 hours here so that the board is aware of it. The subject matter is that, as the board members are all aware, there is a pending federal lawsuit concerning SMAC versus the town of Stoughton. There was a hearing yesterday in the federal district court. I'm not going to go into too many details about everything that occurred, but I wanted to make the board aware of the subject matter and the outcome at the very least. Just backing up for a second, the board would probably recall that it received some correspondence concerning allegations regarding a few members of the board, some conflict of interest issues, and other claims about whether or not the board could, those particular members, could participate, or whether or not the board could proceed with this hearing tonight. That issue was brought in front of a judge of the Boston Division of the Federal District Court. There was a hearing yesterday afternoon at 3:30. At the conclusion of that hearing, the judge determined, after hearing all the allegations of conflict of interest, violation of law, etc., to deny that request to postpone or stop this hearing, and to deny the request to disqualify or otherwise prohibit two members of this board from participating in this hearing. So I wanted to make sure the board was aware that that occurred yesterday, that the judge issued a ruling denying those requests, and therefore the board can proceed with item number 2, which is the public hearing that's been scheduled for this evening. Thank you, Mr. Chairman. That's the update.
May I ask a question about that? Mr. Chairman, may I ask a question? Thank you.
Oh, sorry. My microphone was off, so thank you, Mr. Winter and Mr. Gito. Go right ahead.
Can anybody hear me here? Can you hear me now? I guess my question is, I will speak louder. Can you hear me? I'm sorry for my back here. I thought the question of conflict of interest was determined by the Ethics Commission in the state of Massachusetts, not the federal court. Am I correct or not correct? Is that within their jurisdiction?
Mr. Chairman, with your permission,
Yes, sir.
Mr. Gito, is that a question to me?
That is a question to anybody who would like to answer it.
I'm happy to respond if it's the board's pleasure. So a conflict of interest under the Massachusetts Conflict of Interest Law is within the jurisdiction of the Mass State Ethics Commission. That doesn't mean that someone can't raise those claims to us, raise those claims to the Mass State Ethics Commission, or raise those claims to a judge in any particular forum. Those aren't the only claims, I understand, that were raised. Those were a portion of the claims that were raised. And so it's up to the judge to decide how to handle such claims when they're raised, in this case, her courtroom, the judge's courtroom. I don't want to discuss the nature of the arguments or argue or get into the details of that case, since we are not in a federal courtroom right now. And that's for another place, another time, and for another authority, who's certainly not me. So I don't want to get into the details of that, but what I did want to make the board aware of is that those were the nature of the claims, and the judge denied those claims. The reasons for it and what arguments were made, it's irrelevant for our purposes tonight.
Thank you, Mr. Winter.
Just a quick follow-up. If there, it was my impression that certain courts had jurisdiction over certain activities. And I didn't think that the federal court would be dealing with an issue that is a state issue in this case. You're a lawyer. I mean, I'm just trying to understand this.
And again, Mr. Chairman, if I may, there's a distinction between the claims that people can bring in a courtroom and whether or not the court decides that that court has jurisdiction, and how to handle said claims when they're brought. The court doesn't have control over what claims are brought and how they're brought. And so again, I don't want to get into opining on the jurisdiction of the federal court and how federal judges manage their courtrooms. It's none of my business. But we were served paperwork alleging these claims that matured into an allegation or several allegations that were brought before the federal district court. That was heard yesterday, and the judge denied the relief that was requested. The relief being to stop or prohibit this hearing, or to prohibit two members from participating in it.
Thank you, Mr. Winter.
Thank you.
So our next item on the agenda is a public hearing. As is our custom, our vice chair handles the public hearings. For the purposes of the public hearing, please direct comments through her as the acting chair. Thank you.
Thank you, Mr. Chairman.
Sorry, yes? The public hearing, no. There's nobody speaking at the public hearing. Okay. Fair enough. One second. I'll turn that question to our attorney, since we happen to have one.
Well, we haven't opened the public hearing yet, so we're still on item number 1. I don't know if the gentleman has something to say on item number 1.
Do you have anything to...
We haven't initiated the public hearing yet, so I think, Mr. Chairman, that's what you were alluding to, correct?
Yes. Okay.
And Mr. Chairman?
Yes.
The public hearing is to start at 7:25, correct?
Thank you. We have 10 minutes.
Right. That's
I
the point
appreciate that.
wanted to make.
Thank you so much. Yeah, so no, I appreciate it. The public hearing has... Oh, no, sorry. It was advertised for 7 o'clock. It was just that it was on our agenda for 7:25.
If it's a time certain on the agenda, we should stick to the...
Okay, fair enough. Okay, so we will take a 10-minute recess, and we will return.
Or 7?
Sorry, do you want to be heard? Okay, coming up. What's going on? So we right now we're discussing. So we're about to take a recess, but we're discussing the SMAC lawsuit. Is this relevant to this case?
Yes, it is. I have material that the town of Stoughton and the Board of Selectmen would be pertinent to this whole case.
Okay,
I
so
was the
it's relevant
former
to this case?
station manager at Stoughton Media Access, and David Young was the former access coordinator at Stoughton Media Access.
Okay.
Yes. Sorry about that. Thank you.
Okay. If you, I'll let you speak for a moment, but I want to keep it just brief, and it has to be relevant to what the business before us tonight. Okay.
So 1 minute.
I just ask you to keep it brief.
Okay. My name is Mark Lindy. Mr. Chairman and Select Board members, I'm a resident of Bridgewater and an elected town councilor there who had served in the paid capacity as the station manager at Stoughton Media Access. I was born in Stoughton, I respect the citizens of Stoughton, and I love Stoughton. I am here to share relevant and important information as a former employee with my colleague David Young, former access coordinator, regarding SMAC's infidelity to its contract responsibilities with the town of Stoughton. The leadership of this board of directors is directly relevant to the situation that brings us here tonight. The town of Stoughton finds itself in an untenable relationship with SMAC that has caused grave concern. Before joining SMAC as the station manager, I read an exhaustive report by the esteemed and experienced Mark Hausman, commissioned by the board of directors. The findings of this report created fear with regard to the behavior of individual and collective actions of the Board of Directors, with John Stagnone as president and Stephen Bates as treasurer. Regardless of the findings of the report, I chose to accept this position, assuming that the report had resulted in a change of behavior. Unfortunately, I encountered and experienced the same behavior from the leadership of the board outlined in the Hausman report. Through you, Mr. Chairman, I would like to provide factual testimony regarding my firsthand experience with SMAC, which I'm certain you will find relevant to the fact that past and present directors of SMAC not following their contractual obligations to the town of Stoughton. Mr. Chairman, I've read the agenda with regards to contract compliance and have prepared my remarks consistent with the format outlined in your agenda. There are several points. I believe I have the floor, sir.
Okay,
There are
please keep
several
it brief and
points
to the
that I'm
point, okay?
certain would be of significance to the board members as you determine the appropriate actions you will take with respect to SMAC and its board of directors. I'm following the points that are in the public hearing notice.
Okay, so we're not right now. We're talking about the lawsuit.
It
Okay.
would have to do with the lawsuit.
Okay. Yeah.
Do you want me to continue or stop?
Mr. Chairman, can I offer a comment?
Okay. Yeah. Continue. Yes, sir.
Just to offer a comment, I know you asked the gentleman to be brief. We're still on item number 1, which includes discussion of the Stoughton Media Access Corporation v. the Town of Stoughton and Media Access Agreement dispute. But just to remind the board, as I stated a couple of minutes ago, we're not in the public hearing yet. And so respectfully, Mr. Chairman, if you could encourage the gentleman to be brief and make the point. We are going to have a public hearing following this, and there'll be opportunity for people to give testimony at that time.
Okay.
Should I continue in public
Yeah, please.
comment?
Yeah. But go ahead. Wrap
I
it
have
up, though.
I addressed each one of the points, so it's not particularly brief. I can come back during the public hearing comment,
Okay. Yeah.
and I'd like to bring my colleague.
Okay. Thank you very much.
Thank you.
So thank you very much. We've got about 5 minutes before we can roll on. We're going to take a 5-minute recess. Board meeting of, you're not able to hear me? So I've just called to order the Select Board meeting of Thursday, October 9th again. The time, please, guys, it's time to settle down. We're moving on with this. It's 7:26, and we're opening the public hearing. As I said before we started, before we took the break, the chair, our vice chair, oversees the public hearings. That is our custom, and to make all comments through the vice chair as the acting chair. Thank you.
Thank you, Mr. Chairman. I will read the notice of the public hearing into the record. Pursuant to Article 8, breach and sanctions of the August 9th, 2023 Access Corporation Agreement between the Stoughton Media Access Corporation, the Select Board will consider whether a breach occurred of 1, Article 11, Section 4, which requires SMAC to, within 45 days of the full execution of the agreement, i.e., by September 23, 2023, update and amend its bylaws. 2, Article 5, Section 5, which requires that the President of the SMAC Board of Directors or his or her designee provide the Select Board with a quarterly update on the status of operations and capital planning. 3, Article 5, Section 9, which requires that reviews, reports, or audits of SMAC's finances and operations be conducted and provided annually by SMAC to the town within 90 days after the close of SMAC's fiscal year or within 60 days after the filing of its state and federal tax returns. 4, Article 5, Section 11, which requires that at the time of filing the annual review, report, and/or audit, SMAC provide an inventory of its equipment and facilities together with a statement of its conditions and corrective action, if any, taken or recommended to be taken to maintain all items in satisfactory condition. And 5, Article 5, Section 11 of the agreement, which requires that SMAC prepare and approve annually a revolving 3-year capital budget, which shall be included in the President's quarterly update to the Select Board. The Select Board will also determine whether that breach, if found, was cured or otherwise excused or waived. Lastly, the Select Board will consider whether to, 1, withdraw SMAC's designation granted under Article 3 of this access agreement and thereby terminate the agreement, or 2, impose liquidated damages, or 3, impose any other sanctions as may be lawfully determined to be reasonable under the circumstances, or 4, excuse or waive the breach for good cause shown. Because this is a serious legal proceeding, and because, as well as we all know, there are ongoing legal matters concerning the town and SMAC, I have asked Town Council to assist the board with this public hearing and to lead us through the process. I understand that Attorney Winter is prepared to give an introduction and let us know about the process and give a presentation to the board. Now, with that said, I asked Attorney Winter if he would consider allowing Mr. Lindy to come forward and speak before he gives his introduction, since he was interrupted.
Should we open the public hearing?
Okay.
I make a motion that we open the public hearing.
Second.
All in favor?
Aye.
And I vote aye as well.
So, Madam Acting Chair, you asked me a question about taking Mr. Lindy out of order. As you know, we have a schedule for this evening, but I understand Mr. Lindy felt it important to bring something to the board's attention or speak to the board on item number 1. We determined that wasn't appropriate for him to proceed because we were outside of the public hearing. Now we are. So if you wish to take him out of order, I'll respect your decision. But please, two things. One, we're going to swear in any witnesses that are going to give testimony during the public hearing. And I would ask that he direct his comments towards the specific items that are noticed in the public hearing, and that he keep his comments brief, noting that we will, after we hear from myself and my presentation and give SMAC an opportunity to be heard, and its representatives and council, we will take public comment after. So yes, please proceed, but let's keep it brief, knowing that we have some matters to attend to here.
Thank you. Mr. Lindy, please step forward, and you're a representative or associate.
Thank you, Chair, and thank you, Attorney, it's Winner? Did I say it right?
Yes, winner.
Winner, okay. Just for the record again, Mark Lindy, my address in Bridgewater is 56 Michael Road. With me is David Young, who is a Stoughton
Swear them in.
resident. And
Mr. I'm
Just
sorry,
one
just for a moment, if you're planning on providing some testimony to this board to be considered during the public hearing, I just asked the acting chair to swear you in.
okay,
Or I can do it if you want.
So, Mr. Lindy, do you swear to tell the truth, the whole truth, and nothing but the truth?
absolutely, yes.
Thank you very much.
Okay, so I'll stick to the points like I was asked for that are listed in the public hearing. During my tenure at SMAC, I worked on the bylaws of the organization utilizing my 37 years in leadership roles at public access organizations. I was told by then Board President John Stagnone that it was a board matter and wasn't for me to be involved in as station manager. The prior station manager before me, Michael Hammond, was told the same thing. He was here much longer than myself and could not be here tonight due to an important work commitment. Number two, as station manager, I worked on financial information to provide to the Board of Directors. I was told it was the treasurer's responsibility and also of Mr. Hausman, who prepared financial statements. My prior experience in my job allowed me the expertise to do so. There was never an actual treasurer's report presented or prepared by the treasurer, Stephen Bates. All checks were signed and authorized by President John Stagnone. My access to bank statements was limited, and then the statements didn't come to our mailing address. They were sent elsewhere. For a nonprofit, adequate checks and balances were required by law. There were none. Point number three, an outside auditing firm, CPA, was engaged in Chelmsford, Mass. I wanted a Stoughton or nearby CPA firm to do our filings and was told it was none of my business. Both the previous station manager and I were told we didn't submit information on time for financial reviews, which was false as we both kept time date stamps on all of our submissions. IRS filings were not done on a timely basis with extensions. On the last day of my job, I received an IRS notice documenting this. The state annual reports were also filed late. I received a directive to do this a certain way by the president of SMAC, John Stagnone, and it wasn't my role to pick the CPA firm. IRS guidelines suggest new audit and accounting firms every 6 years. This one was employed over that time frame. The treasurer wasn't a part of this process. It was controlled by the president. Point four, equipment inventory records asked for by the town that were never submitted to this day, to the best of my knowledge, were impossible to track. I tried to update them despite inadequate records. Old equipment was never properly disposed of, stored upstairs behind locked, closed doors. Previous records were never available to me as the station manager. Any record was then created by me. I suggested inventory tags with barcodes, but were told they were too expensive. There was always a veil, a veil of secrecy hovering around any records at SMAC. Number five, I was tasked with creating both a capital equipment and facility budget. I was told that the considerable stockpile of subscriber revenues given by the town of Stoughton to SMAC was to be used for, quote, a studio reserve, and we were not allowed to buy simple equipment necessary for the operation of existing SMAC studios. All expenditures were micromanaged by one director. This was the overreaching theme during my brief tenure: secrecy and noncompliance. Under nonprofit rules and IRS laws, a nonprofit is held to the highest possible standards. The board had specific roles: policy, providing financial resources, and exercising their fiduciary responsibilities as a collective board. The day-to-day operation was left to the station manager. Micromanagement and surveillance were the culture at SMAC instituted by the board president, Mr. Stagnone. Without board authorization, unless done in one of the many secretive executive sessions, a camera recording system that may have included audio recording was installed with direct view of administrative operations, nearby bathrooms, entrances, and exits. The alarm codes were set by Mr. Bates and his preferred vendors to watch every move. The vendors had a close personal relationship with Mr. Bates and Mr. Stagnone. This was a clear conflict of interest and against nonprofit rules. I want to make it brief. There was a report that was issued by Mark Hauserman that the board of directors of SMAC commissioned prior to my hiring as the station manager. Despite that report, I thought things would be followed in that report. They certainly were not, and I think all of this is germane and pertinent to your quest to find out the truth, and I am glad to be able to submit it.
Madam Acting Chair, thank you, sir. Do you want me to proceed? I see that you're with someone. Is anyone?
Please state your name.
Sir, do you intend to speak as
My
well?
name is David Young, Stoughton resident, 809 Sumner Street. Everything that Mark Lindy had just mentioned, I was with him when all this was taking place as we were.
I'm sorry, let me just, I'd also like to just swear you in
Yes.
real quick.
Say the same thing.
Apologize.
That's
Make
okay.
sure I get the language right here. Sir, do you solemnly swear that the statements you're about to make is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much.
Okay. So yes, it is true what Mark Lindy had said. But as I was with Stoughton Media Access since the beginning, since like day one. So I've seen a lot. What I can comment about specifically is the treatment of the employees because of the board of directors. Whether that's relevant to what we're talking about, I don't know. That would be your decision on whether you'd want me to continue regarding the character of the board of directors.
If you're asking whether or not we're looking for testimony as to how employees were treated, the answer is no.
Okay.
That is not one of the items within our purview or for this evening. Is there anything else that you wanted to say, or was that the sum and
That
substance?
was basically it, yes. And that I was with Mark when all this took place,
Okay.
and we worked
Chair,
together.
Madam Acting Chair, can I make a suggestion here, just because we've gone out of order and we've just heard, I'm not entirely clear what we just heard, but it's beyond the scope of some of the things that we're here to talk about. Can we just take a 5-minute recess, because I think we need to get back to the agenda and get on track with the hearing that we've scheduled. If you could just hang on for a minute, I'd like to just suggest we take a quick recess.
Yes, I approve a quick recess.
Hello, everyone. I call us back in session. Let's go back in session. I understand, Attorney Winter, you want to make a comment or a statement?
Are we back on? Is everything caught up? All right, thank you, Ms. Roberts. I just wanted to say briefly, we got a little off track in taking public comment out of order. As you'll hear in a minute when I make some introductory remarks, our intent is to take some public comment at the end. But also, we're here for a very specific purpose that's noticed in the agenda, And also, this board has a very specific jurisdiction. This board is party to a contract, and that's the only thing we're here to talk about. Now, I'm not going to tell you that I understood everything you said, and quite understood some of the variety of topics you brought up, but I want to be clear that some of the things I heard are concerning. Some of the things I heard appear to be serious allegations, but those are allegations and statements that are really outside of the contract we're here to discuss tonight. So some of those things are within the jurisdiction of other state and federal authorities that are not us. I'm not your attorney. I'm not telling anybody what to do, but there are other jurisdictions, state and federal, that can speak with you about such matters. This board is not one of those. And so you can choose to pursue that as you wish. That's your business, not mine. But I just want to make clear that, some of the things I heard about the IRS, nonprofit corporations, requirements, and things like that, those are not things that this board has jurisdiction over. And so we'll leave that to you and whatever you do with it next with any agency you see fit to communicate with. The second point I want to make is, and this is for the board members, whether or not those issues are taken to a state or federal agency is none of our business. And so I'd ask you, just as we proceed through the public hearing, there may be times when we hear things that are outside the four corners of what we're doing tonight. We'll try to bring it back to the purposes that are noticed and for which we're holding this hearing. And so at the end of this process, the board is going to close the public hearing at some point and undertake deliberations. And so I'd ask you to, and I'll assist the board with this when the time is right, to only give weight to the things that are within the board's jurisdiction and that are relevant to the noticed matters on your agenda and the public hearing notice. And so things that are outside the scope of that, and you'll hear me say this again at the end of this process, and maybe sometimes during the middle of it too. But the only things that you should consider in your deliberations are things that are relevant to the contract that was entered into between this board and SMAC, the terms of that contract, and during the relevant time periods. And so things outside of that, please don't validate those or give them any weight, and we'll leave that to the good gentleman here to do with as he sees fit. I do see that you have something in writing. Was it your intent to submit that or provide that, or are you just providing your testimony? Okay, so be it.
I can certainly give to the board anything I have in writing that I spoke of for the minutes, for the reflection, for the record.
It's your choice. You'll hear in my remarks in a minute, this isn't a courtroom. We don't have a judge. We'll try to adhere to some level of the rules of evidence. We're not going to adhere to all of them because this is a public hearing and not a trial. And so we don't have the ability to exclude or rule on evidence here. We do to a certain extent, but not the way you would in a courtroom. And people have the right to file things with their town government. So it's your choice, sir, and I'll leave it at that. And with that, Ms. Roberts, you ready to proceed? How would you like to proceed?
Yes, Attorney Winter, please proceed with the process in your presentation. No, we're going to proceed with our process at this time, which is the presentation by Attorney Winter and the presentation.
And I'll just remind Ms. Roberts and the public as well that I intend to make a brief presentation. We'll invite the representatives of SMAC to come up and make a presentation as they see fit. And then we will have a period to take public comment if it's, again, relative to the issues before the board and specific to those topics. And so I'll be mentioning this, I think, a few times this evening. And so just so the speaker is aware, there will be an opportunity for that, just not right this moment. So if I may proceed, Ms. Roberts?
Please proceed, Attorney Winter.
So I prepared a few introductory remarks. And first of all, good evening, everybody. My name is Brian Winter. As you've heard, I'm an attorney at Mead, Tallerman, and Costa. I serve as town council to the town of Stoughton. And before we, began the hearing in earnest tonight, I just wanted to go over a few matters. Some of the remarks I'm about to make are for the board's benefit. Some are directed to everyone here in attendance tonight. First, although you've heard quite a bit of this so far, I wanted to give an introduction as to the nature of these proceedings here. And second, I wanted to talk about the procedures, how we're going to run the hearing tonight, and so that everybody has an understanding of what we're doing here, why we're doing it, and then how we're going to do it. And the first point I want to make is that this is a public hearing. Many of you are probably familiar with the public comment period that the Select Board often has on its agenda. This is not that. This is a public hearing. There's a very important difference. During public comment, there's a public forum. The public can speak on virtually any topic. Public comment is a type of public forum. There's a First Amendment right that attaches to that. Folks might remember the Barron v. Southborough case. There was a lot of chatter about that, about people's rights during a public forum and a public comment period. This is not that. This is a public hearing for a specific purpose with specific topics. The subject matters were identified in the public hearing notice. They're on the agenda, and anything outside of that, we're going to do our best to rule it out of order and bring it back to what's on the agenda and what's on the notice. So what are those topics? The hearing that was noticed concerns a service contract between the town of Stoughton and its vendor SMAC. That contract requires the town to follow a process in the event the town believes that SMAC may be in breach of contract. That process began in earnest on October 1st, 2024, when the board provided notice to SMAC of potential breaches of the contract. That October 1st, 2024 notice identified a number of contract provisions that the board alleged SMAC may be in breach of. Just to set the stage here for a second, and bear with me, I'm just going to read those contract provisions, and it's a little lengthy, but just to give the board a chance to refresh its memory and give the public an opportunity to hear it, understanding some people may be hearing it for the first time and not familiar with the contract. I'm just going to run down this briefly. Article 5, Section 5 is entitled Cooperation with Municipal Government. And it states, the president of the SMAC Board of Directors or his or her designee shall provide the Select Board with a quarterly update on the status of operations and capital planning to facilitate communication, transparency, and compliance with this agreement. That's the first one. The second is Article 5, Section 9, review, annual report, and/or audit. And it states, reviews, reports, or audits of its finances and operations shall be conducted and provided annually by SMAC as may be required by the regulations of the Attorney General as they may be amended, to its members, if any, to the Stoughton Cable Advisory Committee, to the issuing authority and municipality, and if requested to licensees within 90 days after the close of SMAC's fiscal year or within 60 days after the filing of its state and federal tax returns, including any extensions, etc. Current Attorney General guidelines provide that an audit is required if an organization's gross support and revenue exceeds $500,000 in a fiscal year. Organizations with gross support and revenue of more than $200,000 up to $500,000 in a fiscal year are required to complete an annual review. And there's an important paragraph following it, and I just want to read it. Bear with me, because the purpose of the preceding paragraphs was to allow this board to perform a function. And it says, review of SMAC's performance by the municipality, its issuing authority, or its designee, if conducted, shall be conducted 15 days after receipt of the annual review, report, or audit from SMAC, and written notice to SMAC, or at such other time as mutually agreed by the parties. The performance review shall be conducted at a duly noticed meeting of the Select Board, at which SMAC shall be heard. At any such performance review, all SMAC officers, directors, attorneys, agents, or managers requested by SMAC, the municipality, or its issuing authority or designee shall be in attendance. In the event the municipality determines it requires a designee or third party to conduct a performance review or audit, such third party shall be impartial, objective, disinterested, and professionally qualified. Any substantive issues, deficiencies, breaches, or defaults raised or found by the municipality, its issuing authority, or its designee as a result of the performance review shall be provided to the SMAC Board of Directors by written notice within 60 days of the performance review, and any determination shall follow the procedures set forth in Article 8, Section 1 of the agreement. The next provision that's cited in the notice is Article 5, Section 11, maintenance of records, equipment, and property, equipment inventory. Annually, at the time of filing the annual review, report, or audit, SMAC shall provide to the issuing authority an inventory of said equipment and facilities together with a statement of its condition and corrective action, if any needed, taken or recommended to be taken to maintain all items in satisfactory condition. SMAC shall prepare and approve annually a revolving 3-year capital budget that identifies equipment requiring replacement due to obsolescence or that has or will reach the expiration of its anticipated useful life during that 3-year term. This information shall be included in the President's quarterly report, update, to the Select Board in accordance with Article 5, Section 5 of this agreement. And then the last section, Article 11, Section 4. The Access Corporation bylaws, as adopted by the incorporators at the time of incorporation and thereafter as may be amended, shall serve as the effective bylaws of the Access Corporation. The Access Corporation agrees that within 45 days of the full execution of this agreement, SMAC shall update and amend its bylaws as may be necessary or advisable to be consistent with this agreement. So those are the contract terms. The other relevant terms concern the process and proceedings for breach. I'm going to return to those at the end. And certainly when the board goes into its deliberations, we'll talk about that process and what the requirements are for that. So after the board serves its notice, identifying the alleged areas of breach, which I mentioned earlier, occurred on October 1st, 2024, the contract gives SMAC a chance to respond, which it did in several ways. After that period of notice and response, the board must hold a public hearing. After the public hearing is closed, the board must then decide if a breach occurred, and if so, whether to impose a remedy for that breach. Again, this proceeding here this evening is to fulfill the board's contractual requirement to provide SMAC, its vendor, with a public hearing. So you've heard me say it before, I'll probably say it more times tonight. Only the contract is relevant, and under the contract, the board has the exclusive right to determine how to proceed if it finds that its vendor is in breach. One more word about what the hearing is not. So I've told you about what we are doing tonight. I just want to mention it sort of conversely, what we're not doing tonight. This is not a forum to discuss the federal case. We don't discuss pending litigation outside of executive session typically, although I've given the board an update tonight. That case concerns other matters that overlap but are far beyond the contract issues that we're discussing tonight. So not only is that discussion of those matters outside the scope of this tonight, But that case is ongoing and pending, and I'm certain that this hearing and statements made in this hearing could be used as evidence in that case. So to be clear, once again, we're not going to entertain discussion or argument of the federal case. This is not the place to try it or argue it. Second, let me go back to the process now. This is the board's hearing. This is not a trial, as I stated before. We, the board members here, are not plaintiffs. SMAC is not a defendant. We don't have a judge here tonight. This is more akin to something like a congressional hearing, if you will. The board is here to hear presentations. We may ask some questions along the way. Board members may ask some questions. I may ask some questions. But the board is not here to answer questions. The board is not the subject of this hearing. SMAC's performance under its service contract is the only subject of this hearing, and that's the only matter before this board. So I'm going to start with a presentation to the board. Board members, I'm just going to ask you to respectfully ask you to listen. Think of yourselves kind of as jurors here. You're the adjudicators of this matter. After my presentation, we're going to give SMAC and its representatives and attorneys an opportunity to make whatever presentation they wish to make. We may have some questions for them at that time. And when that is done, as I mentioned earlier, we'll open it up for some public comment. But if and only if those comments are directly relevant to the contract matters that are before the board tonight. Again, that's not an open comment period. It's not a public forum. And this is not, forgive me, but this is not a chance to just air grievances. This is a public hearing just for these purposes. So we're not going to recognize people unless they have comments that are directly related to the contract or the subjects identified in the public hearing. So with that, let's get underway. So I'm going to ask the board to bear with me a little bit here through my presentation because I want to walk the board through the timeline here. So I've provided what you have in front of you, a 3-ring binder with the materials that I'm going to be referencing. Not expecting anyone to read this along with me. I'm going to highlight things as I go through. These are all documents that, for the most part, you've seen before. These are all more or less public records. And so a lot of these things you may have seen before or be familiar with, but I'm going to ask you to bear with me because I'm going to go through this a little bit methodically and in a way that may be a little bit slow and maybe a little painstaking as I explain why I've included these and why I'm refreshing the board's memory and bringing them to your attention. So there's going to be essentially 3 sort of stages of this. And the first one I want to talk about is how we got here, right? How did we get to this hearing? How did we get to this contract? What brought us into this posture that we're in here today? Then I want to talk about the here. What is it that we're talking about? What notices did we give? What was the substance of that? And what was the response that we received? So those contract terms and the letters we received, the materials we received, and so on and so forth. And then I want to talk a bit about, towards the end, how all that relates to the allegations of the breach that we've alleged with respect to the breach. After that, SMAC, as I've said, is going to have a chance to make its presentation. We'll take public comment, and at the end of that, at some point when the board is satisfied that it's the appropriate time to, we'll close the public hearing, and the board will have its deliberations, and I'll assist the board in whatever findings or determinations it wishes to discuss at that matter, and whatever process it wishes to discuss at that matter. But once the public hearing is closed, the public hearing is closed, and then it becomes board discussion only, as per the usual. I know you've all been through these before. And then if the board obviously finds that there is a breach or breaches of the contract, we're going to need to discuss what the contract provides for in terms of remedies. So let me begin. So you have a notebook in front of you, and you don't need to follow along, but you're welcome to follow along. I'm going to explain why I included these things and what the significance of them as I go along is. And so, the first thing I want to start with, and as I mentioned, it's the how we got here. So the first document in here is the original contract. This is from 2009. So as the board will recall, it had entered into a contract quite some time ago with SMAC in 2009 and initiated this relationship with a vendor to provide municipal cable access services here. On page 4 of that agreement, it provides that the agreement was in effect for 5 years. The agreement obviously would have expired 5 years after that. There's some evidence that it was extended until 2022, but this is where it begins. And so there are a couple of provisions in here that I just want to draw your attention to briefly because they track forward and they're significant to what we're talking about tonight. And some of these appear on page 9. Section 12 includes a provision that there should be no amendments to bylaws without notice to the issuing authority. And it provides SMAC shall not make any substantive material amendments to its bylaws without first presenting the same to the issuing authority for review and comment, together with an explanation of the desired amendment and the reasons therefor. So keeping in mind, this is the 2009 contract, not the current one. Under that, there's another provision which you'll recognize. Section 13, maintenance of records, equipment and property, equipment inventory. And the relevant part of that that I want to bring to your attention is it says annually at the time of filing the annual review, report, or audit, SMAC shall provide to the issuing authority an inventory of said equipment and facilities together with a statement of its condition and corrective action, if any needed, taken or recommended. So as you heard a couple of minutes ago, that's a provision that exists in the current contract and is tracked forward. So this is where this story begins. The next exhibit is what happened in the interim. So you know that that contract was valid for 5 years. And so during that period and going forward, we learned, and there was communication, of course, between the SMAC Board of Directors and the town. And the next document that's in here that I want to bring the board's attention to, although I'm not going to spend too much time on it, is a document entitled SMAC Evaluation Findings commissioned by the SMAC Board of Directors. And it's dated, July 14th, 2020. And so this was a set of findings and evaluations, recommendations and conclusions that were conducted and written up by Mark Hauserman. There are a number of findings and matters raised in this. I'm not going to read this. There are a couple here that I'll just summarize in that there was concerns raised about the state of bylaws, some internal management issues, recommendations were made, concerns were raised, and this was essentially an audit, an evaluation that was commissioned by SMAC itself and reported to them on July 14th, 2020. And you can read it for yourselves there. But that was a report given to SMAC by someone it itself commissioned. So fast forwarding to 2023, after the Hauserman report, another review was conducted by a law firm, KP Law. And again, I'm just noting it in terms of the travel of this case and the history. I'm not going to go through this. This predates our current contract. But I want to highlight it because it's important for the board to recall how we got here. And in the circumstances in which the board entered into the contract negotiations and ultimately a new contract with SMAC in 2023. So this exhibit, which is on tab D, goes through a number of findings that an attorney Hewig made. Again, I'm not going to read this or go through it verbatim, but it acknowledges the Hauserman report. And beginning on page 3, under Roman, actually capital letter D, it begins an evaluation of SMAC's performance. And there are a number of things here. Section lowercase a, failure to give proper notice of annual special town meetings. Lowercase b, failure to give proper notice of meetings open to the public. Lowercase c, failure to maintain proper financial records. D, failure to maintain proper financial records. E, failure to maintain proper financial records. F, failure to follow requirements of 39 MGL 23B. G, failure to comply with procedures of board of director appointments. H, observations in the July 2020 Mark Hauserman report. So this is lowercase h is Attorney Hewig reciting some of the findings of the Hauserman report and including that and incorporating that into his report, and the report goes on. So again, I don't want to go into the substance and detail of it because it predates our contract, but I want the board to understand in 2023, we had a 2020 evaluation and a 2023 evaluation, and the board was aware of this and understood some of the concerns, some of the criticisms, and some of the work that two separate individuals had laid out, one commissioned by SMAC, one commissioned by the town to look into its operations, its adherence to its bylaws, its financial requirements, et cetera. And so this was some of the catalyst for some of the negotiations going in. And so that's how we got to the negotiations. The next thing I want to talk about are some of the events and topics of those negotiations. So if you turn to the next exhibit set, this is E. I provided a document. We were contacted, of course, more than once, even predating 2023, but going back to 2022 into 2023 by SMAC with an interest in establishing a new contract. And so in June of 2023, we were entering into a meeting with SMAC's council and representatives here at Town Hall, and through work with our stakeholders, we put together a term sheet for SMAC. Some of the things that we would be looking for, this board would be looking for, if it were to enter into a new contract. And it's worth noting at this point for the members of the board isn't obligated to contract with anyone. The board can seek services for the provision of all kinds of municipal services, et cetera, however it sees fit. It can undertake procurement, it can do it other ways, but the board is never legally required to contract with any particular party. It's a voluntary choice to enter into a contract with someone. And in this case, a vendor for media access services. And so entering into these negotiations, the board established a number of criteria that it wanted to see addressed if a new contract were to be executed. And so I just want to highlight a couple of these things. There are a number on this document, 10 I think, but not all of them are particularly relevant to tonight. And the first one is that at the outset, and this is June 14th, 2023, the board had requested that the agreement should provide that there be an independent 3-member oversight committee consisting of 2 select board members and the town manager, authorized and required to liaison with SMAC to facilitate communication, transparency, and compliance with the agreement and SMAC's bylaws. That's one. The second one is that the agreement should provide that within 45 days, SMAC's bylaws should be amended so that the provisions are consistent with the new agreement if there is to be one. The third one is that SMAC funds should be deposited and maintained in a banking/financial institution located in the town of Stoughton. The fourth is that the agreement should provide that SMAC annually submit to a financial audit by an appropriate CPA firm mutually agreed upon by SMAC and the town, and that the results of the audit be made available to SMAC and the town. The fifth one is that the SMAC prepare and provide annually a revolving 3-year capital budget that targets old equipment that's failing or that is likely to fail or reached the anticipated expectation of useful life during that 3-year term. The sixth is that the agreement should provide that SMAC comply with the open meeting law. The seventh is that the agreement should provide that all SMAC meetings, unless exempted by law, should be audio and video recorded and live streamed and or made available on SMAC. And then the last one, there's others, but the last one I want to highlight is that SMAC should make a presentation and report to the Select Board on a quarterly basis, which shall, at a minimum, include the status of operations and capital planning. So that's where the negotiations started. And if you turn to the next exhibit, F, this is just a highlight for the board that multiple drafts, and in fact, a number of drafts of the agreement were redlined, discussed, and negotiated. Obviously, the next exhibit is going to be the actual agreement that was ultimately executed. But I wanted to provide this to you to show, because it was 2 years ago, and it might not be fresh on everybody's minds until tonight, what were the concerns of this board entering into this contract? And as I mentioned before, a lot of the concerns, as just highlighted and actually recited in this contract in several places, were communication, accountability, and transparency. And you'll see all the red lines in here are negotiations of terms with SMAC and its representatives to try to find a reasonable basis that addresses those things fairly to SMAC, but also fairly to the board and the town it represents. And so you see, if you look at the second red line version of the contract on page 6, and I know these are difficult to flip around. Like I said, I'm going to read these to you. You don't necessarily have to follow along with me. But a lot of these provisions, and in fact, predominantly all of the provisions that we requested, made their way into the contract and ultimately into the executed contract. One of those provisions was that the president of SMAC, the SMAC Board of Directors, and or his or her designee provide the Select Board with a quarterly update on the status of operations and capital planning to facilitate the things I just mentioned: communication, transparency, and compliance. That made its way into the red lines and continued through to the final version. If you go down to page 8, there's additional language about reviews, reports, audits with respect to finances and operations. As I just mentioned in the term sheet and before, that was added into the agreement. The provisions about those reports, those reviews, and those audits, giving this board a chance to conduct a performance review of SMAC on an annual basis, that's in the contract as well. Those drafts included that language. And that's the better part of a page, so I'm not going to read all of that to you, but suffice it to say, it's in there. On the next page, on page 9, SMAC shall prepare and approve annually a revolving 3-year capital plan and provide that to the town. As I've mentioned before, these were all the things that were either refined or included. SMAC providing its banking and financial institution and services at a local bank in the town of Stoughton. Page 13, providing their bylaws as amended. Excuse me, let me restate that. Within 45 days of the full execution of this agreement, SMAC shall update and amend its bylaws as may be necessary or advisable to be consistent with this agreement. So you've heard that before. That was in the draft from virtually day one. These are the things that we were looking for. One of the changes that was made in that instance was that the board didn't need to approve, because we don't run nonprofit corporations. They're a vendor, and we don't, we're not involved necessarily with those things, but we do supervise and steward the contract that was entered into. And so the intent was not necessarily to approve them, but we do have an interest in ensuring that they're consistent with the law and consistent with the contract. And so that was the amendment that was required of SMAC. The next page, the next set of draft red lines, I'm not going to go through all of these again, but you'll see that these provisions continue to get refined. At the bottom of page 9, you'll see that we tried to add language that included the audio-video recording of SMAC meetings and that they be live streamed. Again, as an agent of the town, these are the requirements that we, as town agents, live up to. We are subject to the open meeting law. We live stream our meetings. We record our meetings. And so we're asking for some parity, again, in the name of communication, transparency, and accountability. Notice of board meetings for the SMAC Board of Directors, agendas and, the typical requirements that we do for every single meeting. So you'll see that those were added into this draft. And similar with the other provisions I've mentioned, reporting on a quarterly basis to this board, updating the bylaws, and some of the other things that I've hit upon previously. And so I want to move to now, we've gone through the negotiations. There's been a series of email exchanges, meetings at Town Hall, et cetera. And now this is culminating in what we believe to be a new contract with SMAC. And so the next, if you go to tab G, we have some minutes from the select board meeting where we brought this back to the board for the first time now. And I just wanted to read, a couple of statements that are reflected in here. And so the title of this item is SMAC Corrective Action Plan. And I'll just read a couple of highlights here. Chair Roberts commented that she is willing to work with SMAC toward a cooperative solution. Mr. McCrisky stated that he had spent considerable amount of time and effort to understand the status of the relationship between the town and SMAC. He is interested in restoring goodwill. On March 28, 2023, the Select Board sent a letter to SMAC requesting a review of the current practices and compliance with the requirements of the board to be completed within 45 days. A response was received May 9, 2023. Mr. McCrisky is happy to see the willingness of SMAC to work with the town to reach a comfortable agreement. I'll skip forward. Mr. Carrara questioned if the concerns surfaced by Mr. Hausman would be vetted, and it stated that a list of failures had been received from town council. Mr. McCrisky responded that the concerns will be addressed, adding that he believed SMAC should be given the opportunity to develop a plan to address them. Mr. Carrara said he'd like to know what the plan is and what will be done to improve the situation. Skipping forward again, Mr. Coulter commented that the function of the liaison group and SMAC will be to produce an action plan. We have volunteers on both sides. Part of the plan will include an advisory board. The town manager said his job is to work to present an agreement favorable to both parties. The negativity needs to be eliminated. That's May 16th, 2023. H, the next tab. This is just a series of emails, so the board, if it wishes to, can refresh its memory on all the exchanges that were going on at this time, which is quite many emails and letters and meetings going back and forth. Just a couple things to highlight. There's a few emails in there from our team to SMAC's representatives, asking them to contact us. There's one item I need to discuss further with you, the open meeting law language, and some other, just evidence of the work that this board put in and the issues it was concerned with are just sort of reflected here and there throughout these documented exchanges and conversations. And towards the end of this packet, I'll just read it for you so you don't have to find it, is an email back to us. And it says, please find a red line version of the revised SMAC access agreement. My edits are currently in red and address the items on the term sheet. As we discussed, we included the items, I think 6 out of 10 that the town requested. The other items we either agreed were not necessary or are deal breakers for SMAC. So suffice it to say, there was a robust and ongoing exchange and conversation of ideas and interests there leading up into the ultimate contract. On the next page, it's tab I believe. I provided the board with an update at that point. This is July 19th, 2023. Again, another public record. I advised the board on the status of the negotiations. And you'll see here that on all 11 of the points I made in our first term sheet, I stated what they were, and I advised the board on what the update was for that. And on each one of those, you'll see that we believe that an agreement had been reached and that SMAC was willing to sign an agreement that included those measures for transparency and communication and accountability, all as detailed in those 11 points. And so that's on July 19th, 2023. And you'll see that that continued on to the next report, which is the next tab J. And I provided an updated report on August 10th to this board. And again, going through each of the 11 items and advising the board on where we came down on each one of those. Again, noting that SMAC voluntarily agreed to sign a contract that included each one of these items. And so the next tab K is, of course, the agreement signed by both parties. So if you look at the last page, the date is August 9th, 2023. Stoughton Media Access Corp. By its president, Robert Mullen, president duly authorized. And so this is the ultimate contract that we are now operating under. And I'll just direct you to a few of the pages where these terms now appear. The structure changed a little bit as we progressed, but the relevant terms still appear in here. On page 5, you'll see the language requiring the president of SMAC, board of directors, and/or his or her designee to provide a quarterly update to the board with respect to operations and capital planning to facilitate communication, transparency, and compliance with this agreement. On page 7, you'll see the language about reviews, annual reports, and audits. So that requirement is in the executed agreement, as you've heard a few times from me today. Section 11, which appears on page 8, an inventory of equipment and facilities together with statement of condition. That appears in section 11 on page 8 of the contract. On the next page, the 3-year capital plan. On the bottom of page 9, section 16, SMAC was not comfortable agreeing to be subject to the open meeting law, although an agent of the town and an honor's assistance, we believe that it should be, but the final language of the contract that they're governed by, as are we, is that the open meeting law doesn't apply, but that all meetings of the board of directors shall be open to the public unless the board in its discretion decides to enter into a private session of the board of directors for the purposes of conducting sensitive business. And it continues on. So that's one of the things we asked for that did not make it into the final agreement, although we tried to honor the spirit of that requirement in a different way. If you continue on to page 13, the language about the bylaws, updating the bylaws within 45 days, as may be necessary and advisable to be consistent now with this new agreement. So that's the present contract that we're operating under. And so the next tab are the board meeting minutes from just after this. And so I put these in your packet just to highlight what happened next after this agreement was signed and the parties began this new chapter. And if you go to page 6, the first thing that the board did shortly thereafter, signing the contract, is consider appointments for 2 vacancies on SMAC. And the minutes reflect that Ms. Roberts nominated for reappointment Mr. Bates and Mr. Mullen, and the board voted 5-0 to reappoint Mr. Bates and Mr. Mullen back to SMAC. So this is the first step that the board took after entering into this agreement. And if you look at the next 2 tabs, I'm just going to go through these very, very quickly. These are the letters that the board sent. The first one to Mr. Bates, This letter will confirm the vote of the Select Board to appoint you to a 2-year term on the Stoughton Media Access Corporation. This term will expire June 30th, 2026. The tab following that is the same letter addressed to Mr. Mullen. This letter will confirm the vote of the Select Board to appoint you to a 2-year term on the Stoughton Media Access Corporation. This term will expire June 30th, 2026. So I'm going to pause just for a quick second. First of all, because I want to take a sip of water. And second of all, because we're going to enter the sort of last phase of the presentation that I wanted to provide to you tonight. And so that's how we got here and where we're at. And now I want to talk about what brings us to this evening. So if you turn to the next tab, this is tab O. The board, after consideration, elected to send a notice to SMAC by certified mail and first-class mail. And the title of that is August 9th, 2023, Access Corporation Agreement, Article Roman numeral 8, Notice. And I'm just going to read the first paragraph, because this is what began the process that brings us here tonight. So reference is made to the August 9th, 2023 Access Corporation Agreement between the Stoughton Media Access Corporation and the town of Stoughton. A copy of the agreement is enclosed for your reference. It has come to the Select Board's attention that SMAC has neglected several material requirements of the agreement. This notice is being provided to you pursuant to Article 8, Breaches and Sanctions. And then continuing on the first page, it says, more specifically, Article Roman numeral 11, Section 4. The agreement requires SMAC to, within 45 days of full execution of the agreement, update and amend its bylaws as may be necessary and advisable to be consistent with the agreement. The Select Board has no evidence SMAC has complied with Article 11, Section 4, despite the passage of over a year since the agreement was executed. Article 5, Section 5. The agreement requires that the president of SMAC and or his or her designee provide the Select Board with a quarterly update on the status of operations and planning. No update has ever been provided despite the passage of over a year since the agreement was executed. The next paragraph, Article 5, Section 9, reviews, reports, or audits of its finances or operations shall be conducted and provided annually. I'm just going to skip ahead because you've heard this language before. The Select Board has no evidence SMAC has complied with Article 5, Section 9, despite the passage of over a year since the agreement was executed. The next paragraph, Article 5, Section 11. The agreement requires that at the time of filing the annual review, report, or audit, SMAC shall provide an inventory of its equipment. Again, skipping down, the Select Board has no evidence SMAC has complied with Article 5, Section 11, despite the passage of over a year since the agreement was executed. And then the following paragraph, Article 5, Section 11 of the agreement requires SMAC shall prepare and annually approve a revolving 3-year capital budget. Again, the Select Board has no evidence SMAC has complied with Article 5, Section 11, despite the passage of over a year since the agreement was executed. And then at the end of the letter, the board now intends to conduct a review of SMAC in accordance with Article 5, Section 9. This, however, cannot occur as SMAC has not yet met its obligations under the agreement. In accordance with Article 8 of the agreement, we therefore invite you now to address the above matters within the time period provided, i.e. within 60 days of this notice, and to request an appearance on the Select Board's agenda so that the Select Board may receive the required quarterly update on the status of operations and capital planning, which we assume will be cumulative of the time since August 9th, 2023, when the agreement was executed. We thank you for your anticipated cooperation. Look forward to hearing from you. So that was October 11th, 2024, so approximately a year ago now. The following exhibit is a letter that I sent accompanying that, requesting all the documents that we had expected to receive under the contract. On tab Q, I included an email exchange between the town manager's office and a representative of SMAC, because now we're up to over a year since the contract was executed. And no representative of SMAC had at that time requested to or appeared before the board. And so there's an email exchange that I thought was particularly relevant. And it states, Hi, Gilda. As chair of the SMAC Board of Directors and in compliance with the Select Board's Chair Stephen Cavey's letter dated October 1st, 2024, I'm asking that SMAC be added to the Select Board's agenda under the topic of SMAC's President Quarterly Update. I am suggesting the date of Tuesday, November 19th, 2024. So this is on October 28th, so almost a month after the board's notice was sent out. We get an email requesting to have SMAC present at the November 19th, 2024 meeting. And the response is, good morning, I will keep you posted. Now November 13th. So that was October, 28th. Now on November 13th. The next email in the exchange is, hello. The quarterly update will be held on Tuesday's Select Board agenda. Do you have backup for the board? If you do, I'll need it by tomorrow. Please let me know. And later on that day, also on November 14th, the response from Mr. Mullen. SMAC was served with legal documents from Town Council in addition to Chairman Cavey's October 1st letter. So this is about a month and 14 days, a month and a half after those letters went out. And so now we're being advised, this board's being advised, that SMAC is acknowledging that documents had been served in addition to Mr. Cavey's letter. SMAC has engaged counsel to itself to assist us in responding to both these demands and claims of the town, as with events that have transpired since we were served. SMAC will be providing our response, including the information for a quarterly update requested by Chairman Cavey through council, and with our response to town council. So that was on November 14th. And needless to say, a meeting before this board did not occur at that time. So the next tab, this is R if you're following along, is a response provided to me on behalf of the board as the board's representative from counsel, legal counsel to SMAC, and it's dated November 27th, 2024. A great deal of this letter concerns what I am going to characterize as subject matters that are within the federal case now, and so I'm going to begin on page 8 and not discuss the first 7 pages. And what's relevant, in my opinion, for tonight is where the letter starts, as to SMAC's response to the Select Board Chairman Cavey's letter. And there are several paragraphs that comprise SMAC's response to the board's letter and to my letter. So the first section concerns the bylaws. So you'll see SMAC's position recited there. No bylaws included, no materials provided with respect to that item at that time. So just to refresh the board's memory, now we're November 27th, 2024, a year and quite some time after the contract was executed, and no documents were provided in response to item number 1. With respect to item number 2, the quarterly updates to the board, you'll see that there's SMAC's position statement recited in there. The board's received this letter before, but I want to refresh the board's memory. I'm not going to, of course, read it verbatim tonight, but you do have it, and you've had it before. In the third paragraph, review annual report and audit, Article 5, Section 9. And in this section, SMAC provided documents in response. And so now, here we are at the end of November in 2024. We received documents that consist of a Form 990, which we'll talk about in just a moment. And if you go down to paragraph 4, an inventory of equipment. And if you go down to paragraph 5, 3-year capital budget also attached. And so these are the first documents that we received since executing the contract in August of 2023. If you turn to the next tab, I've only provided a cover sheet here, and I've redacted it heavily. This is just to show the board that, in fact, this document was included in that letter. This is the Form 90. It's titled Return of Organization Exempt from Income Tax. So without characterizing it too much at this point, I just want to provide this for the board so that you can see that this document was provided in response to the board's request for financial report, audit, or review. Let me skip forward here. Item T, if you'll move on to the next tab, is a multi-page document, Stoughton Media Access Corporation. And you'll see it's a table with various columns and lines describing equipment, et cetera. And the second set of documents included in there is a 2-page document titled Town Hall Equipment, 3rd floor, SMAC Control Room, Inventory List. The first 4 pages at the beginning of this set of documents is titled Studio Equipment Inventory List, 421 Page Street. So that's the inventory list. So again, November 27th, 2024, we're getting that document now. The board's getting that document now. Tab U is a document titled SMAC Capital Plan, FY23 to FY27. You'll see that's a 3-page document that follows. So now we've gotten SMAC's response to the board's October 1st notice. And so the board met and considered it and issued a letter, and this letter is included as the next tab, and it's January 29th, 2025, addressed to Mr. Mullen, President, Board of Directors. And I'm just going to read the relevant portion of it, which I believe is the second and third paragraphs. Please be advised that the board met on January 21st, 2025, and considered this matter and your November 27th, 2024 response. After careful consideration, the board elected to take the matter under advisement and not to, at this time, make a determination under Article 8. Rather, the board desires to take an interim step in a good faith effort to resolve this matter by inviting you to meet with the designees of the board at a mutually convenient time at Town Hall to review the matters set forth in the board's October 1st, 2024 letter to you and your November 27th, 2024 response. And then the last paragraph, in extending this invitation, the board reserves all rights under the agreement to proceed under Article 8 as may be appropriate and warranted at a future time. That being said, the board's designees look forward to meeting with you in a good faith effort to resolve this matter, limit the issues in dispute, and or determine a mutually beneficial path forward. The next document is dated February 3rd, and it's an email from SMAC's counsel to me. And I will tell you, there isn't a document that reflects that, but there were many telephone calls that preceded this email where I discussed with SMAC's counsel our desire to have proof that SMAC's bylaws had been updated and that those bylaws had been updated to be in compliance with the current contract. And so SMAC, through its counsel, responded to me. You'll see their position is laid out in a page and change length email, and there are several attachments to that. If you turn a couple pages, let's see, to the fourth page, this is what we received in response to that, and I'll just show the board. It's a one-page document, and it's the cover page of the SMAC bylaws, dated, or it states effective, amended by SMAC Board of Directors, effective September 30th, 2023. So we received the cover page. We also received minutes of a November 25th, 2024 meeting, and I should say redacted minutes. And on the last page of that, you'll see that there's a note that says the board reviewed, it's Article 8, and it's titled Bylaws. The board reviewed the amended SMAC bylaws, which have been in effect since September 30th, 2023. Steve Bates made a motion to accept the amended bylaws, seconded by Gina Coe, unanimous. The rest of the minutes are redacted, and again, the bylaws were not provided, just the cover sheet to the bylaws. And you will see in the preceding email that I provided to you, there's an explanation which SMAC and its representatives can address themselves if they want as to why they believed that this board should not be privy to those bylaws. And I'll let that speak for itself, and SMAC's representatives can address it if they wish. So notwithstanding that, the board has promised, identified 2 designees to meet with SMAC. The next 2 tabs you'll see, these are just notes that I included as placeholders to note for the board that these meetings occurred. On Friday, March 14th, 2025 at 4 p.m., a meeting occurred between SMAC and Select Board members Roberts and Carrara at SMAC's offices. On the next tab, a second meeting occurred on March 28th, 2025, 4 p.m., between SMAC and Select Board members Deborah Roberts and Mr. Carrara at SMAC's offices. So that brings us to March of this year. And I just want to pause for a second here because the next set of documents are sort of a bellwether moment in this process. And so I really want to direct the board's attention to the next series of communications. And I guess we're up to tab Z now. So there's an email, and it's an email from SMAC's counsel while these meetings are occurring between 2 representatives of this board and SMAC. And I'm just going to leave it for you to read for yourselves, but I want to go down to the last sentence on the first page, where SMAC informs us and provides a draft copy of a federal lawsuit and raises certain claims and makes certain statements. And so this is on April 5th, 2025. And so after the series of events that I just described, from March 28th, 2025 to April 5th, we've now been given a copy of a draft federal lawsuit that is purported to be soon to be filed and served upon the town of Stoughton and several board members in their individual capacity. So if you'll turn to the next exhibit, and you'll see there's quite a time gap in there because, as the board knows, that lawsuit was in fact served subsequently on this town. And I'm not here to discuss, and we're not here to discuss the substance of that, but it occurs at an important moment of the timeline. And so I just want to refresh the board's memory that when we received a copy of that and ultimately were served, things took a different turn at that point, indeed. And so there weren't any further meetings between the board's representatives and SMAC. SMAC's counsel the town's council, and other law firms and groups became involved at that point. And so the next communication is an update on July 22nd, 2025. And so now we're approaching the 2-year mark. And it's a second set of documents that were provided to me and others. And it includes a studio inventory, a town hall control room inventory, and a new tax return, a Form 990, with current dates on it. If you'll look at the next tab, a heavily redacted, just cover page associated with that is included. And it recites tax years 7/1/23, or a term, excuse me, 7/1/23 to 6/30/24. So now, 2 years in, we are receiving this second Form 990 return. And you'll see on the next set of documents, which are tab CC, a new inventory list, or a second inventory list, I should say, which includes the studio equipment and control room inventory lists. And so that was the only communication that we received from SMAC going through to July of this year. Obviously, there were proceedings that were occurring outside of the contract dispute and events occurring, but with respect to the board's requests for compliance, the board's request for communication, the board's request for transparency, that was the last document we received. It was the July 22nd, 2025 set of documents and communication, which then precipitated the next letter, which is your next tab, which is September 11th, 2025. And it's the notice of October 9th, 2025 Select Board hearing pursuant to Access Corporation Agreement, Article 8, breach and sanctions. And that's the notice that began this hearing. Following that is the actual published notice for this hearing. And that brings us through to today. Since that time, we haven't received any other formal communications with respect to the contract or any of the documents requested or obligations. We obviously noticed the public hearing, and we're all here tonight to discuss those topics. I do want to mention there's another few tabs in the 3-ring binder that I provided to you, FF. I'm just going to touch on this briefly. At the time this was prepared, we had received a letter dated September 24th, 2025. It is signed by Mr. Steve Bates, Treasurer, Stoughton Media Access Corporation. I believe all the board members received it. I received it more than once from several different sources. And it's, I'll just characterize it very briefly. It's a request, or shall I say demand, that certain board members and the town manager not participate in this evening's hearing. We already addressed this at the beginning of this evening. I included it because I didn't know that there would be a hearing in federal court yesterday. There was a hearing in federal court yesterday. The judge heard the subject matters that are within this letter, and as you heard me report earlier to you tonight, denied that request. And so that exhibit is now essentially a moot point, and that we don't have to consider it and decide how to handle it because a federal judge has already disposed of it. The last set of exhibits, before I make a couple sort of comments in conclusion, is just for your benefit. Just to sort of put some numbers to the timeline and the process here. And for the board's benefit, I went through the board's agendas and minutes. To give you a sense of when the contract was signed, when we received documents, and what we've received through today. And just to put it in a little context, the contract was signed on August 9th, 2023. Today is obviously October 9th, 2025. That's 792 days, 26 months, over 2 years. And the important part of that, and I'm not trying to be petty by reciting all these numbers, the important part of that is that for quarterly reports and appearing before this board, there's been 8.6 quarters since that contract was signed. There's been 73 select board meetings since that contract was signed. And again, just to give you context, from before the first notice was given by this board of an alleged breach, that would be August 9th, 2023, to October 1st, 2024, when the first notice went out from this board. That was 358 days, or 11 months. That's 4 quarters, and there had been 41 select board meetings during that time. And then flipping it on its head, from October 1st, the date of the first notice, to today, that's 373 days, another 4 quarters, and another 32 select board meetings. So just to put the timeline in context, 2 years goes by really fast. I thought 73 select board meetings would provide a little bit more context for the board. So I'm not going to go through any of those meeting minutes. They're all public record. They've been on the website ever since they were posted. And you're all can review them if you see fit to. So I'm going to save, I tried to keep this presentation facts, just walking through the documents and the timelines, and I'm trying not to make any arguments. As I mentioned here before, this isn't a trial, you're not plaintiffs, they're not defendants, and I'm not a prosecutor. So I'm just trying to present the timeline and the facts to this board. And so I'm going to save any further comments or arguments or related to the significance and any inferences you should draw or might draw from those facts to the board's deliberations. I've talked long enough. I'm sure other people are waiting to talk. So let me conclude with that. And then the next step, just turning it back to you, Acting Chair Roberts, the next step would be to invite SMAC to come up. Give them an opportunity to be heard. Please swear any witnesses in that they want to present. You don't have to swear in their counsel. And give them a full and fair opportunity to be heard. We may have some questions for them, but at the conclusion of that, that's when we'll begin what I'm going to call limited public comment, as I've described before. And so with that, thank you for bearing with me. I know that was a lot. I apologize for going slowly, but there was a lot to say, and I wanted to do it at that pace so that people had a chance to at least incorporate and digest a little bit of what I was saying, since it's so much to go through in one night. So thank you for that opportunity, and I'll turn it back over to you. And one other thing, I know we've been going on for a while, and we already took a break before. There's no reason why the board can't take 5 minutes anytime it wants to. Perhaps now is one of those times.
Thank you, Attorney Winter. Let's take a 5-minute break. 6 minutes according to Mr. Carrera. We'll take a break.
Everyone. Hello, everyone. Let's call the meeting back to order, please. Hello, everyone. Let's call the meeting back to order, please. It's 9:12 p.m. And this is in regards to the terms of the contract. I ask the attorneys to step forward, and anyone that is a witness
to the discussion regarding the contract and the contract only. If you are a witness to the contract, please stand so we can swear you in. We don't swear attorneys in because they're already sworn in. If you want to be a witness to the contract, please stand. So I see one person standing. I see two people I see three people standing.
Okay.
Attorneys, please come to the front desk.
Someone changes their mind, we can swear them in later.
Yeah. Okay, so those,
What
for
would-
those standing? I don't want to interrupt you, sorry.
Mr. Chairman, please swear the witnesses in.
Thank you, Madam Vice Chair. To those standing, do you solemnly swear that the statements you are about to make is the truth, the whole truth, and nothing but the truth? Thank you so much.
And that is Mullins, and that is Anya. Hello, and how are you? Please state your name, attorneys, and then we can start the discussion regarding the reason we are actually here, according to the agenda. Thank you. Oh, wait just a minute. Let's see if I can get an additional microphone.
Just turn it
Press the
on.
button at the bottom so it'll go green for you.
Okay. Okay. Jill, grab one, too. Okay. So it's three. So there are two. Okay. There are three microphones. Maybe the third attorney would like a microphone? I don't know.
You got 4.
Okay. Everyone has a microphone. Thank you very much.
And you might have to hold them a little closer. There you go.
Do a sound check. That might be a way that we could do this. Yes.
First, thank you very much. My name is Attorney Joseph Zappo for Stoughton Media Access Corporation. I'll try to be as brief as I can.
Before you start, can you introduce your other?
Certainly, I was.
Good evening. My name's Zachary Wallach. I'm also an attorney for Stoughton Media Access
Zachary
Corporation.
Wallach.
And I'm Dave Murphy, attorney for Stoughton Media Access Corporation.
Thank you very much, Mr. Attorney Zappo.
So first, thank you for taking the time to see us. I know that you have a lot of business, and this has been pretty lengthy, admittedly, already. So thanks for making time in your schedule. I wanted to just touch a few points that I felt needed some attention in Attorney Winter's summary of how we got to this point. In the November 27th, 2024 letter that I responded to both Attorney Winter's letter and Select Board Chairman Cavy's letter, there was some 66 pages of documents. So it wasn't, my letter, my exhibits were like 77 pages. The letter is 22. I might be miscounting 55. So we made a good faith effort to cure the issues raised in the letter. As to the bylaws, and that seems to have gotten some attention, the access agreement's language is not actually exact in the notice, though it is in Select Board Chairman Cavy's letter. And it says that it's within SMAC's discretion to amend them or not amend them as may be advisable. So it's discretionary, but we did, and we wanted to provide, excuse me, evidence that we had done so. Stoughton Media Access Corporation is a private corporation, and Attorney Winter and I think the emails that might be in one of your exhibits, shares the rationale that we were concerned that providing bylaws makes them public, and we didn't think it was a good idea to do so. And one thing I'll also has to be sort of emphasized with respect to these quarterly reports, that I guess it's the position of Attorney Winter should have been requested, and that is that Attorney Winter's letter threatened litigation. It was a litigation hold letter. So a litigation hold letter literally isn't enforceable unless there's litigation contemplated or likely. So when someone sends a client a litigation hold letter, it says, I think I'm going to sue you, so you need to retain all these documents. Against that backdrop, it's difficult to have open discourse with respect to anything like a quarterly report, although it isn't beyond picking up a telephone or asking for a meeting, and there were some meetings. You know, in I guess the early spring there were meetings, and Attorney Winter and I were in active communication, and I thought that the first issue dealt with in Select Board Chairman Cavy's letter was adequately dealt with, and I thought we both had agreed to that. If that's not the case, then it's not the case. But I think one of the goals tonight is to try to narrow, if we can, the areas of, you know, what documents, what information isn't there that the Select Board would like to have. Because what's troubling to me is that the October 1, 2024 letter and the, I don't want to use the term too loosely, the September 11th, 2025 letter instead of 9/11, they're the same defaults, even though we spent the time and effort, and I thought it was all in good faith, to exchange some 50-plus pages of documents. And by the way, the July email that Attorney Winter referred to is the annual report. It wasn't just sort of it wasn't clear to me in the presentation that that was not presented as just some sort of willy-nilly email, gee, you know, here's some documents that didn't go anywhere. You know, there's a specific time frame for submitting it, and we tried to adhere to it, and that's why it was sent. And also, prior to that, in the November 27th letter, there was the same content to speak to that issue as well. I tried to remind Attorney Winter in my letter, and I hope you read it, our rationale for, you know, the bylaws and saying, look, we didn't have to, but we did amend them. I thought the open meeting law made it pretty difficult for SMAC to operate. I mean, it doesn't have the same resources that the town does and access to attorneys. And frankly, I think it's, you know, not a good thing that we've descended to where we are. But if there's an opportunity to put it on track, that'd be great. If there isn't, you know, there isn't. As in terms of the contract breaches, though, I'd really like to narrow the issues, because it troubles me a lot that there was that much information shared, and yet the defaults are the same a year later. You know, that's troubling to me, and it's troubling, period, because you folks are making a decision that's going to have consequences to SMAC, and if terminated, of course, put it out of business, and on the basis of the very same things that were the case a year ago that shouldn't still be the case, unless the documents didn't get to where they needed to get. So if there's an opportunity to make sure that you have what it is that you need, or you explain to us what it is that you need that you don't have. It's pretty clear about the quarterly reports. I've given you our rationale for that. And that doesn't mean that they can't happen, but things like testimony, if there's going to be testimony at a quarterly report in the middle of a case, just like Attorney Winter said, you know, we're not here to litigate the case, and so anything that you would say could be used in the case against you. And that's the issue in the quarterly reports. If there's another forum, another way to give them, let's talk about that. One other thing. I would like to call as witnesses Steve Bates and Bob Mullen and be brief about it, but just to get their slant on how we got to this point. I've not usually seen a contract construed so differently between people as to people parties, as to produce the kind of outcome we've had. And there's been some fireworks, and I know that's not the topic of this evening's hearing, but they had
Can you please stay on
context.
topic, Attorney?
Yes,
It's only about the agreement. Thank you.
but the topic is that we can't ignore the fact that there's pending litigation. We can't, you can't.
Yes, I'm sorry, sir. Attorney.
No, that's okay. That is the topic, though. And so.
The topic is regarding the agreement.
Defaults, yes.
That's correct.
Yes. And one of them is the quarterly reports, right? Okay. So it does relate to litigation. The existence of it, I don't think, is at all a secret, and we've already talked about it. In any event, I'd like to have Mr. Bates give us a statement, and then I'd like an opportunity for the two lawyers on either of my side to add anything that they would like.
Sure.
gonna-
Would you like to add additional chairs to your table?
I could get up.
Okay.
Good evening, how we doing?
Please state your name.
My name is Stephen Bates. I'm the treasurer for Stoughton Media Access Corporation. I want to, I'm going to go off the script a little bit, they're going to kill me, but the statements allowed at the beginning of this were absolutely smear. And some of you should be
Excuse me,
ashamed.
Mr. Bates, please stay on topic.
I'm on topic. They talked about me this morning, when we
Please
started.
stay on topic.
I'm on
It's in
topic.
It's in regard to the agreement.
Well, the people that were talking before me, that had nothing to do with the agreement.
It, yes, Attorney Winter.
Just very briefly, I just wanted to remind the board and the speaker that after that, we took a recess, and I made a statement when we came back that those are matters that, if I understood them, and I'm not sure I did, are not within the board's jurisdiction, and I asked the board to disregard them. And so I just
Okay,
wanted
so
to
I
state
get
that
it.
again for your benefit, that, and I'll mention it when we get into deliberations. Just because they were said doesn't mean we have to accept them or validate them or anything else. And so I just wanted to remind the board that I did make that statement on the record as well.
Well, I heard it, but I understand that it's just unfortunate that you would allow that. You all know better. So, dear Chairperson Cavey, members of the Select Board, I want to thank you for allowing me the opportunity to speak this evening on behalf of SMAC. I want to start out by saying both the Select Board and SMAC offer valuable public services to the town of Stoughton and its residents. SMAC is appreciative of the work the Select Board does for the town, and we're hopeful that the Select Board and the town residents are appreciative of the work and services that SMAC provide to bring programming to this community. It is regrettable that we are here tonight, but we are nonetheless. SMAC would like nothing more than to resolve this dispute amicably, but unfortunately, we have not been able to do so. We remain hopeful that we will, though. I want to first address the defaults that were noticed by Chairperson Cavey in October 24. We do not believe, as Attorney Zoppo has just stated, that SMAC defaulted on its obligations under the agreement. And even if SMAC did default, we believe we provided the documents that show that SMAC cured any defaults in a timely manner. The bottom line is we do not think this is a fight about documents. It truly is. Please tell us what you feel we are missing. We're asking you to vote that SMAC did not breach any of its obligations under the agreement, and if it did breach any obligations, we're asking you to vote that SMAC can cure them. Even if the Select Board believes that SMAC breached its obligations and did not cure them, which we again disagree with, termination is far too severe of a remedy that does not serve anybody's interest. There are much less penalties that are contemplated in the agreement. If you vote to terminate SMAC, hardworking employees will be out of jobs. People who have dedicated their professional lives to providing coverage to the town's residents will be out of work. The town will be without access television provider, and therefore we will be deprived of receiving important news. That does not serve the people of Stoughton at all. SMAC does not believe that, at its core, this dispute is about documents. SMAC believes that this dispute is a result of certain members of the Select Board dissatisfied with SMAC over SMAC coverage. We believe that these actions taken included in the default letter from Mr. Cavey on October 24
Madam Acting
were
Chair,
done
just-
in retaliation for
Excuse me,
programming.
one moment. I just want to remind the speaker that I understand you're making a statement, you have a right to, but we're not going to discuss the allegations in the federal case.
I'm not discussing allegations.
Just please keep it to the contract, not personal allegations regarding any member's behavior that may be the subject of the federal lawsuit. Thank you, sir.
So as I was saying, we feel that this was retaliation for programming that members of the board do not like, and it is
Mr.
deeply
Bates-
unfortunate, as the SMAC was simply doing what it was required to do under the agreement and no way was favoring or disfavoring any political position. In closing, SMAC and the town have an interest in working together. This dispute does not benefit anyone. We urge the board to find SMAC was not in default, and if they do, to impose any number of penalties which will fall far short of termination. It is time for SMAC and the town to work together. It is too important for the residents to do otherwise.
Yes, Attorney
I-
Zeppel?
Attorney Zoppo again. I just wanted to remind, and Attorney Winter, I'm sure knows, that one of the contract provisions is that there not be bias. And so I think that that's why Mr. Bates brought up what no one wants to address. And I understand that, but SMAC does its best to not be biased. And there's objective reports to show that it isn't, and that is a contract provision. It is, I would imagine, an event of default. It's been raised as an issue. I also wanted to just talk briefly about the, and I don't know what this has to do, and I'm not sure the context in which Attorney Winter brought this up, but the 2022 to 2023 dispute, which I thought came out to the satisfaction of both parties. I don't know if that's the case anymore, but I thought it did then. I mean, there was a very serious problem with that letter, and I'd like the board to very seriously consider our response to that Koppelman and Page letter, which is a privileged document, but it was sent to us notwithstanding, and I appreciate that. I mean, it was an eye-opener, but Attorney Winter, recited all these subparts of that letter. I mean, that attorney worked for SMAC, and the information in that letter he drafted, and so it was, to me, quite a horrible thing that an attorney that worked for SMAC is now trying to default SMAC and tell the board how to take it over. And I thought that both Attorney Winter and I did a good job of stepping back from that precipice to come up with the present agreement, which is why we're here today. I'm not even going to address this Hauserman report. It was, someone attached the word audit to it. Mr. Hauserman's, he's not a CPA. I don't even think he's a management consultant. And what was in the letter was fairly troubling because it had to do with an employment relationship with SMAC of an employee. And I thought it shouldn't see the light of day. Unfortunately, it has, and I'm not going to address it further. It's 5 years ago under previous management. I just wanted to make those two comments clear. And the third one is the access agreement, I don't find a provision in it, and I hope when we have an opportunity to narrow the issues, you can invite my attention to where it says that we need to publish our bylaws and make them public. It's a private corporation under Chapter 180, and I don't know any corporation that just makes their bylaws public. In any event, I'll turn it over now to Robert Mullins. I'd like him to say a few words of his impressions with regard to these alleged defaults and attempts to work on them. I just have a technological question. Do you press this to turn it off?
Yes. Good evening to the board and the members of the public and the people watching at home. My name is Bob Mullen. I'm currently the president of Stoughton Media Access Corporation in Stoughton here. I just want to say a couple things, and I definitely, if you give me a moment here, as a member of the Stoughton community, we always work together here. We work things out. Hope we can continue to work things out. That's what's important. What makes Stoughton, Stoughton. Stoughton is one of the greatest communities in the world here, my opinion. And I think we need to continue to work together as a community. I know as soon as you put a few people in the room, everybody has difference of opinions. That's what the world's all about too. But as it relates to SMAC this evening, I'd just like to say that I still think we can work things out, but it relates to the contract. We did meet in March, several liaisons from this select board. I think Mr. Carrara and Deborah Roberts were there, and we were trying to work things out. We met, as the Attorney Winter said, twice during March, trying to work things out. And I don't think we ever got into the details because there were some discussions about certain people didn't want to get into the details of specific actions. But being said, I think we still need to work things out. We're doing this for the people of Stoughton. And that's what's more important than my opinion or anybody on my board or your board. It's for Stoughton, number one. Now, we all pay our different attorneys, and they're going to do everything in the best of each board's interest. But don't forget, we work for the people, and we have a lot of producers here this evening. And unfortunately, the meeting's running long, so a lot of people had to leave for the evening. They had to go home and take care of their basic needs, their family, their homes, and get ready for work in the morning. So I implore you to, number one, give Stoughton Media Access an opportunity to continue. Don't go down this road any further. We need to work things out. If you're willing to work things out, we're here to work things out. And I just want to say that. My attorney didn't think I was going to say anything more than talk about the liaisons. I appreciate meeting with the liaisons. I hope we continue to meet with the liaisons. But unfortunately, once we got that litigation hold letter, it just turned the page on everything. And as our attorney said, it just stopped. It put the brakes on everything, unfortunately. It's unfortunate that we got that letter. But I just want to say that there's still a lot of time and a lot of opportunity to work things out for the betterment of this community. Thank you for listening to me. I appreciate your time.
Thank you, Mr. Mullins. Mr. Zeppel?
Thank you for your time. We don't have anything further.
You had one more witness? It was Anya. That was the third person that was sworn in?
I didn't look behind me.
Oh, okay. That's okay.
I'm going to just step away so that she can sit.
Good evening. Thank you for letting me speak. For you, Select Board Member Roberts, I'd like to take this time to address some of the things that I wrote down that I think are very important and relate what we are discussing here today. Hopefully you will have an opportunity to listen to my staff.
Excuse me, Please state your full name and
sorry.
your position. I know you're a station manager,
Yes.
but no one else
So
does.
my name is Anya Zulavnik. I'm the station manager. I was hired 3 years and 3/4 ago by the board, and I'm thrilled to run SMAC. We just took everything to the next level, and I'm very happy here to address some of the concerns that were raised today and talk about my staff. So as I said, I was hired 3 years and 3/4. It's going to be 4 years in February. And since I've been here, SMAC went through a lot of changes. We have the new board president, we have new 2 board members, all the staff is new, and we went through a lot of changes. Some of the things that my staff is finding frustrating, and you're gonna hear from them, hopefully they will be time to hear from them today, is that sometimes we feel like we're always under attack. Even though SMAC staff is really very diligent and we always, try to do the best job we can, we try to treat everyone in the same way. Somehow it feels, that we're always under attack, even though we're not doing anything wrong. And you will hear from my staff, how it feels to them, being under pressure.
Excuse
and
me,
sometimes not
Ms.
being
Anya.
treating well.
Your comment, is that related to the contract, or you're trying to make a connection?
Yes, I
That
am.
you're under attack and no, oh,
So basically, over 3 3/4, SMAC grew and expanded, and we have experienced growth in every area. And we updated our equipment at the town hall, in the studios, and we do have inventory lists. So when I started working here, I found 2 inventory lists that were made by my predecessors. I don't know them. I spoke one of them a couple of times, and he came to stop by. So I know that SMAC had inventory lists previously as well, and so and we do have it as well now. It's not unusual sometimes to keep old equipment. If something new breaks down or if you need a replacement part, it's not unusual for any station to keep some of the old equipment, around. So we really try to fulfill all the obligations under the contract. We provide training. We expanded our internship program. Every year we get between 1 and 3 students from the high school that we provide training to. We also provide internship opportunities to to students from local colleges. So we provide a lot of training, which is, under our agreement as well. So we take our contract very seriously, and we really try to, fulfill all the things that are included in it. So sometimes it is very frustrating for my staff because they ask me, why we are being, attacked all the time, that like we don't have inventory lists, but we do have inventory lists. We've been all working on it. So, they feel under pressure and they feel like we really are trying to fill all the obligations under the contract, but somehow, things are, there are accusations brought against us, but then, there's like really no concrete evidence that we're not doing something. So it's also, difficult for some of our producers because they know what's going on. And, we try to create a very healthy atmosphere at SMAC, but sometimes it's really difficult because of all the things that are, going on and things that are being said about us. So, for example, that SMAC is being biased, but we are not biased. We really are going out of our way to
excuse me, Ms. Anya, can you bring it back to the contract, please?
Absolutely.
Thank you.
Myself as a station manager, I really try to make sure that we fill all our obligations under the contract. So, when I hear things like this, that we don't have financial records, it's very frustrating because I spend a lot of time taking care of it. And we do have, all the things checked, and we do all the things that we are supposed to do. But somehow out there is, and I hear it sometimes from residents that ask me about it. Even today, some people ask me, is it true that you didn't, submit all those documents? And I'm like, no, we submit everything. And we really do our best to make sure that all the documents are filed, and that, we have a company that reviews our financial records, and that everything is filed. So one thing that I would like to point out to you that is also in our contract, that we have to provide unbiased programming, and we really make a great effort that everyone that comes to the station feels welcomed and supported. And SMAC is only responsible for technical support, and we're not, responsible for content. And we really try to create, welcoming atmosphere, which is also, under our contract, that, every resident has a right to come and record the show, and that we are not biased. And that's, one more thing that sometimes frustrates my staff when they hear things, because we really treat everyone in the same way, just like it is required under our contract. So I'm just going to make a short statement at the end, and I'm pretty much done unless you have any questions. So my staff really take pride in being impartial and taking no sides, just as it's required under the contract. They would never discriminate against someone because of this person's political views or position might be unpopular. They feel like they are being punished because they are doing their jobs. They are truly impartial, and they help every resident to get their message out. Not only they do a great job, but they also have been recognized for being very talented. As you know, last year we got the awards, and we took two first places in 2 different categories. So my closing comment is that we really take pride, me and my staff, following everything that is in a contract with the town, that, we treat everyone in the same way, and that everyone has the same chance to record a show and have their voice heard. Thank you.
Thank you, Ms. Anya. So no other remarks by you, Ms. Attorney Zappel? Okay.
No, thank you.
Thank you. So that's it.
Acting Chair Roberts, can I just
Yes,
make a
Attorney
comment,
Winter.
if you don't mind? Just a quick comment, because SMAC was the subject of this hearing and deserved a chance to state its case. We gave you plenty of license, I believe, to state your case, and tried not to interrupt or cut you off. But I just want to remind you that when we go into public comments, the comments need to be focused on the topics of the contract that were identified in the agenda. The board is not the subject of this hearing or any of its alleged conduct, and I know there are other forums where that's perhaps going to be discussed or examined, but this isn't that. And so just as we move into the public comment period, I want to remind everybody, only comments that are related to SMAC's performance under the contract is relevant. So I know we've said it a couple of times, and I think I told you about 3 hours ago I was going to say it over and over again tonight, so just keeping my word. Thank you.
Thank you, Attorney Winter. Mm-hmm. And that would be Attorney Murphy?
David Murphy, correct.
Please state your name and...
David Murphy, I'm an attorney for SMAC. I hadn't planned on speaking, so I don't have prepared remarks, but given the lengthy history that Attorney Winter went into, I just wanted to remind the board of some of the history.
Excuse me, there's some conversation at the table, and which I have a hearing. No, at this table. Did you want us to stop?
No, my apologies.
Okay.
So
Sorry for the
I'm just going to go
interruption,
into
Attorney
a
Murphy.
brief history of some of the issues underlying the current contract dispute. I started my involvement in this case back when we received the K&P letter prior to, I think, June of 2023. I was the one who was responsible for analyzing the K&P letter and drafting a response on behalf of SPAC, which I did. If you recall, there were many, many problems with the K&P letter. Factually, lots of inaccuracies, fundamental misstatements and misunderstandings of the law. And I think we did a very thorough job of basically undermining almost all of the contentions in the K&P letter. There was reference to a conflict of interest that the public is probably not aware of and that the board may recall, and that is that the attorney at Attorney Hewig for K&P had previously been the attorney for SMAC, and under the rules of professional conduct, you are not allowed to represent a party adverse to a prior client without their written authorization. Attorney Hewig then acted as the attorney for the board in advising the board how to terminate SMAC's contract, which was a violation of the rules of ethical conduct, which we pointed out in that letter. And I called Attorney Hewig to give him a heads up that we were going to make this letter public as a courtesy. Shortly after we delivered the letter to the board, Attorney Hewig was no longer counsel to this board, and you hired Attorney Winter. I won't speculate what happened to Attorney Hewig, but he no longer represented this board after that sequence of events. So after that, I scheduled a meeting with Attorney Winter and Tom Coulter and Steve Cavey and Bob Mullen and Steve Bates, and we all sat down in Tom Coulter's office to discuss issues. And Attorney Winter discussed a term sheet that was provided by the board of I think 10 or 11 items that the board wanted. Many of those were rejected and were not included in the contract that was subsequently signed and is the current contract that SMAC is operating under. For example, the open meeting law does not apply to a private corporation. SMAC is not a public entity in the open meeting law. And this is acknowledged by your lawyer, by your previous lawyer, by the Attorney General's office. It doesn't apply to a private corporation, and that's why SMAC did not agree to abide by the open meeting law. What we did do was we included a provision, as Attorney Winter referenced, referencing that we wanted to comply with the spirit of the open meeting law in making SMAC's board meetings open to the public and providing an opportunity for SMAC as a private corporation to then enter into private sessions in circumstances when they would discuss matters that are not appropriate for public discussion, like internal personnel matters, legal issues. But I just remind the board of these facts because I want to dispel sort of the impression that I think was left when Attorney Winter was talking that like SMAC has something to hide, or that we haven't been open, or that we haven't been forthcoming in providing information to the board. I do want to go back to the meeting in Tom Coulter's office because I offered to sit down with members of the Board of Selectmen and with Tom, who I know from when he served in the legislature, and I actually am quite fond of Tom. I think he's a great guy. We have a very good relationship, and I've always gotten along well with Tom. I think he's a reasonable guy, and I mention this because a lot of the issues that were brought up in the KMP letter were issues that have been regurgitated and in the October 1, 2023 letter as alleged breaches. But, I sat down with Tom and with Steve and with Bob Mullen and Steve Bates and with Brian Winter, and we went through all of the issues that the board was looking for information from SMAC and issues that you had with SMAC, and we worked them out in what I thought was a very productive and reasonable set of meetings. I think we met at least twice in Tom's office for at least an hour each time. We went back and forth, and as Brian Winter pointed out, we went through multiple drafts of the contract that were redline drafts of contract. If people aren't aware, those are drafts in which both sides mark up a document, and then ultimately you come to a consensus and you sign a final document. So the term sheet and the red line versions of the contract are not necessarily things that made it into the final contract, and I don't want the board to be confused in thinking that those items, those 10 or 11 items on the term sheet all made it into the contract, because they didn't. There were specific things that we simply were not going to agree to, not because we weren't being cooperative, but because I felt that the board needs to understand that as a private corporation, there are certain bounds that the corporation is bound by, and we were hired by the town, by the select board, to provide a service to the community, and that's to provide public education and governmental access for the education of the community. And I thought we had a very, very productive process, and that we worked out all of the issues. And so when we signed the contract back in, I think it was about June of 2023, I thought we had put everything to bed. And so I was very surprised when I received the letter on behalf of SMAC from Attorney Winter and from Chair Cavey, alleging multiple breaches of the access agreement that, again, many of them had been resolved previously. Some of them were new, but I think there seemed to be either a misunderstanding or a miscommunication or a lack of effective communication on both sides in terms of providing information. SMAC wants to provide you with the information that you want to provide oversight to SMAC, as is their obligation. And that's always been our intent. I've been a very strong advocate, so I'm not particularly involved in the federal lawsuit. That's been taken over by outside counsel, and Joe has sort of headed that up. But I've been a very strong advocate for trying to reach an agreement with the town, and we are willing to sit down with any member of the select board and with Tom and with your council to try to reach an agreement, because our position is that this isn't benefiting the community. I think that trying to terminate the access agreement with SMAC it's costly. It is. I don't believe it's going to be successful ultimately. It's going to lead to further litigation, and I think that it's in everybody's interest to try to resolve these matters. And I strongly believe that if you're willing to sit down with your attorneys, that we can come to a resolution that works for SMAC, that works for the Board of Selectmen, and for the community. Thank you for your time. We appreciate it.
Thank you, Attorney Murphy. Now I turn to my fellow board members and ask, just do a check-in. Do you have enough information? We've heard from our attorney, their attorney, and 3 witnesses. Attorney Winter.
I think that's a great idea, Ms. Roberts, to do a check-in with the board. We've been going for, 3 hours now. I want to see where people are at. We did promise some public comment, and we've heard a couple of things here. So considering the hour, what would the board like to do with our remaining time? Do we want to hear public comment? and then talk about where we go from there? Or do you want to talk about what we can accomplish tonight with the hours that we have left today? Want to just continue on with public comment? And I'm sorry, Madam Chair, I should be going through you. Respectfully, I ask on your
Hopefully,
behalf.
I understand. So what's the wish of the board? Mr. Carrera?
A question.
We can't hear.
There you go.
I'd just like to ask a question through you, Madam Chairman, to Attorney Winter. Do we get to say anything, or we just got to absorb all this that was said this way, said that way, and it was like it's being said the way we feel, when I'd like to say a couple of things, but if you don't think it's right to say a couple of things, I won't.
So I'd like to, through you, back to Mr. Carrara, I'd like to respectfully ask the board members to save those for the deliberations. You will absolutely get a chance to speak with each other, make whatever points you want to make, discuss how you want to proceed. It doesn't have to be after the close of the public hearing, but I'd like to save that for deliberations. If you have questions or more information that you would like to follow up on, we haven't gotten to this yet, but that might be a good reason to table this. And give those people a chance to respond to those questions. And I would ask you to provide those to me. We're taking this extraordinary step because we have some extraordinary circumstances here. And so if you do have follow-up items, we've heard two things mentioned. You may have some questions, and we heard some documents referenced. Tonight's the public hearing. Anyone can submit anything, so if they have it, they can give it to us. But it's up to the board to decide if you want to give people a further opportunity to do that. So to your question, yes, for deliberations. And if you do want to have any questions passed on or answered, please give them to me, and we can do that.
Thanks.
Attorney Winter, I do see a resident standing at the tape. Oh, I'm sorry.
Wait a second.
Look, this is the check-in. Mr. McCrisky.
Right, no, I believe as well, with the time, that I would like the opportunity for us to discuss and take some intake and reflect on what we've heard tonight from certain people. Unlike some people, the chair, other people that have met, the liaisons, there's a couple of us board members that have not had that opportunity to hear some things. So I think it would be helpful to me personally to be able to know some of those things that were talked about. The attorneys for SMAC have said we thought we had, you know, a plan or something to that effect. I've never heard those things. I've never seen the documents. So I think to make an informed decision, you know, I'm not prepared to do that tonight. So I mean, personally, I would like to see us continue this, or whichever way legally we do that, to be able to deliberate on the information we've heard tonight, and to see if there is a chance, as the attorney said, to try to work together. I haven't been a part of this. This is the first I've heard of a lot of this tonight. I know what we've talked about in the past, which is very little in the whole scheme of things. So that's all I had to say. Thank you.
And I see Mr. Gito.
There are a number of questions that I have of SMAC. Should I send them through you, or is that something that I should ask now?
So through you, Acting Chair, and through you, Mr. Cavey, I would respectfully ask, just again, in light of the circumstances, which are unusual, that if board members have questions, and if it turns out we do table this and come back another night, it's a perfect opportunity. Please send them to me, and I'm happy to ask your questions.
Thank you.
And in this, the list of questions, Attorney Winter, or
Do we need to tell you who we're asking the question to? Is it to one of the witnesses, or is it to the attorneys, or does it even matter?
I can have that conversation individually with a member sending a question to me. The more specific you are, the better result you're going to get. And if I don't understand, I will ask. And so I will communicate, Mr. Gito, if you don't mind me using you as an example, if you send me a list of questions and who you wish those to be directed to, I will review those and work with you. And if I have any questions, I will communicate those to you.
So the next,
Thank you.
Mr. Chairman, did you have any questions? This is just the checking in point.
I appreciate it. I have no questions. Thank you, though.
Madam Chairwoman, I just want to make ourselves available to answer any questions that any members of the board may have this evening and remind them that because the board is represented by counsel, we can't, this is your opportunity to ask questions in this forum. We can't respond to your members directly outside of the presence of counsel. So if you have questions, I would encourage you to ask them now.
And just again, we're establishing a protocol for that to happen. Obviously, these questions would get asked the next evening of the public hearing on record. They would just come to me and I will collect them and we will ask them on the public record to counsel in a public forum.
I see we have a resident standing at the table. That resident didn't go through the swearing in or even heard that this was specific to the contract. So what is your comment to him? Because he's now sitting down.
I didn't see everyone who stood and was sworn in, so why don't we just ask? Were you present when people were sworn in, sir?
I was. I don't consider myself a witness, as more a messenger from the town. I think as a whole, I'm not going to take a stand one way or the other. What I will say, I understand you people have to make your judgment.
Wait just a minute.
Before
Mr.
you begin, again, I'll just issue my standard caution here, which is the topic are the areas of breach in the contract.
Correct.
You've heard it a million times. And second, any testimony to this board is evidence. Whether you deem it taking a position or carrying a message, any testimony you provide, you should provide under oath, sir. And so we're only going to take sworn testimony.
Thank you very
Chairman
much.
Cavey?
Sir, do you solemnly swear that the statement you are about to make is the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much.
I've learned some things tonight which are interesting. I understand that your responsibility is to determine whether the role of the contract, or the stipulations of the contract, if you see it, have been followed or breached enough so that you would proceed with the termination of the contract with SMAC. I have to say, having lived in Stoughton only 44 years, this is one of the more disturbing developments in town, where the selectmen and SMAC are going at it head to head. I don't see any winners here. I understand that if we're being sued by the federal...
Just 1 minute, Mr. Karen.
Yeah, and I just wanted to pause it here for a second because, again, as I mentioned, and I don't know if you were here, sir, when I made this comment, this isn't a public forum. This isn't the select board's typical public comment. We're not here tonight to take sort of opinion on the state of the town or state of town affairs. This is literally a hearing to determine whether or not there's been a breach of contract.
I'm very aware of that, and I'm trying to keep my remarks in that context.
Okay, thank you, sir.
That you people are faced with that decision, you may withhold it, but the decision will finally move you one step closer to decertifying SMAC. I would say we have heard from SMAC tonight they are willing to make compromises to avoid this. They don't want it to happen, they say. I don't think you want it to happen. I would then turn to SMAC and say, I have no idea what this federal lawsuit is about, but I understand from a point of view of a layperson, federal lawsuit goes away, decertification goes away, back somewhere close to square one which wasn't perfect, but it's a hell of a lot better than where we are now. So I would simply ask, as a citizen of the town of Stoughton, and I think I speak for a lot of people, if you can avoid
Let's wrap it up,
reasonably,
please, Ms.
and
McCrary,
SMAC will make
because
reasonable
this is-
compromises, that's what I want.
This is actually a hearing on the contract terms if there was a breach. So thank you very much. Thank you very much, Dwight McCarron.
And may I? Oh, I'm
Wait just a
sorry.
minute, we have
I was just
have
going to
two
remind the
different
board in
ears.
one sentence. This is a legal proceeding. This is a formal legal proceeding, and the board has the exclusive right and jurisdiction to make a determination based on the evidence at the hearing. Opinions about what the board should or shouldn't do, or what SMAC should or shouldn't do. While I respect, your right to have one, and we gave some quarter for you to speak, I just want to remind the board that it's the board's opinion that guides this process. And ultimately, when you get into deliberations, that's not evidence, that's argument. And so we'll talk about that when we get into deliberations. But I just want to be careful as we go forward. I understand that people may have strong feelings one way or another and the desire to express them, but that's different than evidence, okay? So I just wanted to make that comment. Thanks for giving me a chance to.
Thank you, and now Mr. Carrera.
Through you, Madam Chairman, to basically what you said and what everybody else is thinking. Deborah and I were the liaisons who brokered. I was the one who put it up to meet with SMAC because it was going to be all over long ago. And me and Deborah went out of our way to handle things. And those were not just we decided to sit together. We followed a plan according to the contract. It was letters that went back and forth between Chairman Cavey and the lawyers. We sat down and we said, we're going to address this, what the board's entitled to and what's the private corporation. They're a private corporation. It isn't the town of Stoughton against the town of Stoughton. That's one thing you got to understand. They're a private corporation. We have a little jurisdiction, but they're private. So some stuff we're not privy to. But Deborah and I spent 2 days, and then we had to stop. So it isn't, hey, can we work it out? We were working it out, and then things got a little sticky. So things can be worked out, but don't look like we're going to crush somebody because we want to crush somebody. It was getting worked out. And I'm a little aggravated because it's late, I'm tired, and I'm going to get up tomorrow morning and do it all over again. But I just want to say that we were working towards a positive thing. But we had to address letters from lawyer to lawyer and chairman and the town stuff. It wasn't going to get done in 2 meetings. It was probably going to take a while. But it would have got done. That's all I got to say, Brian.
Thank you, Mr. Carrera. Attorney Winter.
I was just going to say, I see that we have one more gentleman standing. Again, I just want to caution that we stay within the four corners of what we're doing here. But if there's going to be a second night, board obviously hasn't decided that, but if there's going to be a second night, it may be more productive to, at some point, consider tabling this and continuing it. In my experience, the later the hour, the less productive things can be. Maybe people will agree with that. And so I just put that in front of you for consideration. So at some point, perhaps after this speaker, because, sir, I saw you were waiting, the board might want to consider that.
Thank you. And after this speaker, I will accept a motion to suspend. And then to table at a date and time certain. Mr. DeFelice.
want me to put my hand up again?
Yes, Mr. Cavey, if you were not previously sworn in.
I'm just taking some notes. Sir, do you solemnly swear that the statement you are about to make is true, the whole truth, and nothing but the truth?
Yes.
Thank you so much.
On the agreement, Mr. DeFelice.
Yeah, I guess I've been the producer there for several years. And one thing I want to talk about, I used to talk to the staff there. There was always talk about equipment. And, you know, if they had something that was failing, they let you know. If it was, you know, if something new came in, they would let you know. So I think as far as that issue on equipment, these guys are really on the ball because some of the people we've had up there are incredible. Some we've lost, unfortunately. And so I think there's plenty there. But there's another thing that, I think it was last year, I went up there to SMAC, right? And normally you'd walk in and whatever. I went up there one day and there was literally 2 locks on the door. And I'm like, what the hell is going on here? I think it's got to be part of this issue. It has to be. And so one had a bell on it and one, you know, was at the door. So I rang the bell and the director let me in. And I said, what's going on here? And she said, well, we just had a few problems. Okay. But the more I thought about it, you know, over the 3 or 4 years I've been involved here, you would just could walk in. Then all of a sudden, something happened between all of you people here that led to this building having a double lock on it. I've never seen anything like that before. But I'm sure that that has a lot to do why we're all sitting here. And she wouldn't tell me what happened, but obviously something happened. And I think whatever that was, I think that's why we're here tonight. And that's something you all should be looking at and find out, what was that all about? I don't know if any of you folks tried to get in there last summer. Normally you open the door and go in, especially as a producer. Had to go through 2 locks.
Thank you,
And
Mr.
That's
D.
all I got to say. I think if, I really think that should be looked into to see what that was about, because I think that's why we're all here.
Thank you, Mr. DeFelice. Motion? Continue to a date and certain?
Yeah. I'll make the
Date
motion.
and time certain, I'm sorry.
Discuss just
You want to just,
what works.
Yeah.
what date works?
Do you want a date or do you want a date to be determined?
Let's do a date, please. if we
It
could have
has to be a
date.
specific date and time. Now, we could continue it again if we pick one that doesn't work, but it needs to be continued to a specific date and time.
Two weeks? Does 2 weeks every
Town
work?
meeting?
When is town meeting?
Oh, yeah. 28th, right? 23rd, 2 weeks.
October 23rd?
Jesus. It could probably be any.
Yeah.
No.
No, and I might recommend, just like we did tonight, doing it on an off day so that you can devote your time and attention to this specifically.
Mr. Chairman,
So today is the,
Madam Chairman,
yes, Mr.
point of
Coulter.
information, if I could ask Carolyn, we have to vote on a collective bargaining agreement before they meet on the 22nd. So if we could do the 2 things together, the vote on the CBA is 5 minutes, but it's got to be done before the 22nd. So if we could
They're
bundle.
meeting, Gilda was saying the 21st. We meet on the 21st.
21st would be perfect. So in other words, we have a CBA that's got to be done before town meeting.
Regular meeting.
If we could put the 2 of them in the same date, that would be helpful.
Excuse me
Carolyn?
for 1 second. Childa, what were you saying? Is the 21st, so we did not want to use the 21st. No.
Carolyn, if I may, Madam Chair, what date is the FinCom meeting?
We're meeting the 22nd, so if you ratify the contract on the 21st, that would be fine.
Or before, sometime before the 22nd?
The contract, the finance committee, in order to consider the contract, make a recommendation, we want it ratified by both parties, so that we have the contract in front of us. that we
Right.
can see it. So we're meeting on the 22nd, so as long as you guys have done it.
Right.
Before then, we can vote on it, make a recommendation, bring it to town meeting.
Thank you, Madam Chair.
Okay. So what's the wish of the board? We have Monday, the 20th, then. We have next week.
If you pick a date tonight, say the 20th hypothetically, and for some reason that date doesn't work, or for some other reason, we can then continue it again. But we need to continue it tonight. So I don't know how difficult it'll be to pick the perfect date tonight. So why don't we pick the best date? And then if for some reason that isn't as good as we hoped it would be, we can always then continue it that night to another one. It's our hearing.
Monday, the October 20th?
21. Joe wants 21. We'll do
October 20th, did you say?
21. 21st.
21st. 21st is Tuesday. Okay. October 21st?
Madam Chair, just be advised that that is a regular scheduled or planned meeting for the boards, so there is a full agenda.
Okay, so October 21st will not work.
23rd? Yeah.
So
23rd.
Carolyn said that she has a FinCom meeting on the 22nd, and she needs to have the, oh, go ahead, just a minute, please.
Carolyn is the 23rd.
The 23rd would be fine for you guys. We're meeting on the 22nd, Wednesday, the 22nd.
22nd.
But our hearing was continued to.
21st is our regular meeting.
So we're
That'll
not gonna
clear
do
up
that.
her. And then 23 we'll do just for,
Okay.
right? We got it set. Sit down.
October 23rd is Wednesday.
At 7:30 so that we can park at this place.
Oh, yeah, October 23rd. So Thursday, the 23rd,
Just for this stuff.
just for this. October. Thursday, October 23rd. Does that work for you? Okay.
Hey,
You?
Madam Chair, just for information, that is the same date as the Finance Committee. It's not. So that would be too late? to-
It has nothing to do with your vote. This is, your vote for the contract is going to happen before us. This is just to, as I understand what the chair is saying, is to continue this hearing to October 23rd, which is Thursday, 2 weeks from tonight. Isn't the planning board meet on the 23rd?
Okay. Okay, we're good.
Okay.
As long as you vote on the contract on the 21st.
What she, that contract that you're referring to is the collective bargaining contract. It has no relevance to this. This continuation to a time certain of this public hearing. So that's what we're discussing right now.
And I completely understand that. It's a 5-minute agenda item as a formality before the
Madam
FinCom
Chairman.
hears it.
Yes, Mr. Carrera?
We're going to continue this meeting to the 23rd at 7:30 PM.
Can I have a second?
Second.
All in favor?
Aye.
Aye.
Yes, I as well. Okay.
Motion to adjourn.
Second.
That is Thursday, the 23rd of October at 7:30 PM, 30 minutes late. May I have a motion? Oh, I'm sorry.
I made a
will
motion to adjourn.
All in favor?
Aye.
Aye.
Aye, and I vote aye as well. Thank you very much.